Hello everybody and welcome back to the Law Academy podcast. In this episode we are going to talk a little bit about the UK-Rwanda asylum deal. Now, I was a bit, lost for what I wanted to talk about for this next episode. I was going through looking at some of the things. This is a little bit like old news to an extent. I mean, it happened last week. I didn't jump on it as quickly as I possibly could, or maybe even should have done. And given the choice between talking about the UK-Rwanda asylum deal and talking about the Johnny Depp Amber Heard defamation case, I jumped on this one because the latter would have been so boring. So what we're going to do in this episode is talk about what the asylum policy is, actually what the implications are for this asylum policy, look a little bit at the backlash of this asylum policy. Of course, it's been universally condemned by everyone from other members of the Conservative Party to United Nations Refugee Council, etc., etc. But then the more important thing, and the thing that we obviously like to do here on the Law Academy podcast, is talk about the legal implications. Because this isn't just a political implication, it's also the legal implications as well. And this means we're going to talk about a number of aspects of the Refugee Convention. We're going to look at the European Convention on Human Rights. We also can look at some previous case law from the United Kingdom Supreme Court, considering the issues of where applicable can the United Kingdom legally deport individuals out of the country if they've sought asylum in a different country, in a quote-unquote safe country, etc., etc. So we have a number of different arguments that can be presented against this new policy that is being implemented, and without a doubt it will be the case that it will be met with legal challenges on the basis of these different arguments that we will get into, and time will only tell whether or not these challenges have any merit in law. But for the most part, most people seem to be of the opinion that there is at least somewhat of an argument or a case to be presented about the illegality of this new policy, and that's what we'll get into later on in this episode. So let's just talk a little bit as a basic introduction, and we're going to talk about this new economic partnership that was announced last week, I believe, or maybe just before, or maybe just the week before, which is an economic partnership in coalition with the government of Rwanda. And it is officially titled the UK and Rwanda Migration and Economic Development Partnership. And what's important about that title is that it is not just a migration and asylum policy, but we're also talking about an economic development partnership. And this is more towards the to provide for safer investment and development in the state of Rwanda, and obviously will cost the United Kingdom a pretty penny. And I'll talk about the cost in a little minute. But this is effectively what I will call from now on the rest of this episode the Rwanda Asylum Scheme, or the UK-Rwanda Asylum Policy. And it seemed to have come a little bit out of left field. Now, there have been talks between countries like Rwanda and other states around the world, for example Denmark, relating to the possibility of a similar kind of asylum policy. But it did seem to come a little bit out of left field a couple of weeks ago, possibly as a result of, or at least in the wake of, the Prime Minister Boris Johnson being issued with a fixed penalty notice for his involvement in lockdown parties. This was something that was announced. The policy itself was announced by the Prime Minister and Secretary of State for the Home Department, Priti Patel, in coalition with the Rwandan Foreign Minister Vincent Biruta on the 13th of April 2022, so a couple of weeks ago. Now, that's effectively where it came from. It just came out of nowhere. I can remember just waking up one morning and seeing, oh, we've done a deal with Rwanda. Okay, let's just see how this goes. But in short, this is an immigration policy that will see individuals crossing the English Channel be relocated for processing, asylum and resettlement, and they'll be relocated, of course, to the state of Rwanda. However, it's slightly misleading to describe it in that way, because as various media outlets have discovered at its announcement, it does not mean that once processed and once asylum has been accepted, okay, that the asylum seekers would be allowed back into the United Kingdom. Instead, the migrants will be deported to Rwanda. When in Rwanda, they will be temporarily accommodated in the capital city of Rwanda, which is the capital which is Kigali, and this will be as their asylum claims are being processed. Once or if their asylum claims are successful, they shall not be given the opportunity to return back to the United Kingdom. Instead, they will be permanently relocated and receive permanent residency in Rwanda. So, some people in the media and just generally within the broader population believe that this was just a method of processing the people who were claiming asylum in Rwanda, and then once their asylum claim and their asylum policy has been accepted, for example, they would be allowed back into the United Kingdom to live out their life as refugees and asylum seekers. However, this is not the case. It's resettlement. It's a processing, asylum and resettlement program, which means that they will not be given the opportunity to return to the UK, even though they entered the UK under the Refugee Convention as being allowed to and as seeking asylum. So, the question you might be asking is, what are the aims and what are the stated aims, at least, of the asylum policy that we have just seen? Well, the most notable of the stated aims is, of course, the deterrence of migrant crossings in the English Channel. But on top of that, there are also a number of other stated claims. To reduce and to stop human smuggling and human trafficking across the English Channel. Now, the extent to which this is a major problem is one that is debated. Of course, I'm not going to get into whether or not it is a significant enough problem to initiate a UK-Rwanda asylum policy, because that is essentially a very, very, very political question. And I want to try and stay away from the politics as much as possible and just focus on the law. But on top of that, there are other stated aims as well. So we also have the aim of boosting Rwandan investment and development, which is namely why it is not just a migration policy partnership, it is also a migration and economic development partnership as well. So we are seeing a boost to Rwandan investment and development through the investment by the UK government. Another stated aim, as Boris Johnson suggests, is to, quote, save countless lives and break the business model of, quote, vile people smugglers. So we see that there are a number of different aims that are presented here. Mainly the aim of deterrence for the migrant channel crossings that are taking place and have been taking place for the last couple of years now at this point. And obviously this is a dangerous trip across the channel, and it is one that has cost countless lives when people have tried to seek asylum in the UK by crossing the English Channel. And so one of the stated aims, I say stated aims because it's important to note that these are the aims that are presented by the government who are initiating the policy. So the stated aims, of course, is this method of deterrence and also to, quote, save countless lives. And in order to boost investment and development in Rwanda, the United Kingdom will pay an economic transformation and integration fund, which amounts to at least £120 million. So we're seeing not only is this a resettlement program, as I've just mentioned, but it again is an economic development partnership with the country of Rwanda. So we're going to see an investment and the flow of capital of £120 million into the state. And as you can imagine, this policy has been criticised on a number of different fronts. There are, of course, moral implications to this policy, but there also seems to be the general practical application that this doesn't seem to make for very good policy at all, considering that the Rwandan government have made it very clear that they will not accept people with criminal records, they will not accept families, and they will not accept anybody under the age of majority. So this does beg the question of who will they accept and what is the scope of this policy. Well, when talking about the scope of this policy, it does seem to have somewhat of a limitation in terms of the scope. As I've already mentioned, the Rwandan government will not accept, and they've made it very clear that they would not accept people with criminal records, families, or anyone under the age of majority. But another example that we can talk about when looking at the scope of this policy is the fact that the policy suggests that anyone who comes to the UK without authorisation could be considered for relocation to Rwanda. And this does present quite a vague description of who is potentially implicated in this policy, and may also be in contravention of the Refugee Convention. Again, I will talk about why and look at the legal implications a little bit later on. But the fact that the general policy that has been described by the Prime Minister and the Secretary of State for the Home Department is that people who are entering the UK with, quote, out authorization will be considered for relocation to Rwanda. This suggests that we have quite a vague definition of what constitutes legally somebody who may be a candidate for this potential relocation program. Now, the Prime Minister Boris Johnson has also said that in terms of the number of people who will be removed, the number itself is, quote, uncapped, which suggests that there is no limitation to the number of people who can be removed and be considered for relocation. He also goes on to suggest that Rwanda will have the, quote, capacity to resettle tens of thousands of people in the year ahead, or the years ahead, if we're using the plural, the years ahead, not just the year ahead. And while this is a significant number who could potentially be resettled, experts suggest that these kinds of numbers are very, very far off, and are probably quite a quite extreme estimation of how many people could actually potentially be resettled. In terms of an appeals process, this is really where we start to see some of the possible legal implications of this policy. In terms of an appeals process, and in terms of the actual process of what is going to happen, it seems to be the case that those who are set for deportation will be given 5 days' notice. And while officials say that most people within that 5-day window will have access to legal advice, there is actually no statutory or official statutory provision that includes a right to an appeal of the decision to have yourself be deported. And this does bring and raise an interesting legal implication of the policy more generally, or the idea of legal implications and legal aid for those who are seeking asylum and are potentially facing deportation. Because under the European Convention on Human Rights, namely Article 6.1 of the European Convention on Human Rights, everyone has the general right to a fair hearing in civil and criminal cases. Now, while this is the case, the question does become a little bit more complicated when it comes to the issue of those seeking asylum and refugee status. Because what is limited here is the concept of civil rights and obligations. And this, under the European Convention on Human Rights, is a phrase that has actually attracted quite a lot of attention and quite a lot of consideration within cases. And according to justice.org, the essential test for whether or not legal aid is something that is required to be provided is whether or not the proceedings are, quote, decisive for private rights and obligations. So under claims of, for example, contract cases or tort cases, they may be covered as part of the Human Rights Convention. However, the justice.org goes on to suggest that cases relating to deportation, asylum and nationality are not essentially covered under this provision. And the cited case here is the P and UK from 1987. So we see here that the first legal question that we have to deal with is this idea of an appeals process, and the idea of, if you are given this 5 days notice for deportation, do you have right to legal advice, and do you have right to any kind of appeal? Well, according to the policy itself, there is no statutory provision that includes a right to an appeal, which is quite a controversial aspect, and may be in contravention of the European Convention on Human Rights. But in terms of the case law from 1987, there is a little bit of a question as to whether or not this will be the case. Now, in terms of the relationship between this policy and other policies in the past, this is just a next in a long line of immigration policies that the UK has passed that appears to at least undermine the spirit of the 1951 Refugee Convention. It might not necessarily represent a direct contravention of the Refugee Convention. That is something that the case law is going to have to decide for itself. But in terms of at least the spirit of the convention, the general hostility towards refugees and asylum seekers in the United Kingdom has been one that has taken place over a great many few years. And we also see, obviously, the merging in terms of the nomenclature when it comes to determining who is an immigrant, who is an economic migrant, and somebody who is seeking asylum. For the most part, these words tend to be used interchangeably, not just in common parlance, but also in Parliament as well. Which obviously, as people who are as lawyers. And people who are studying the law, probably that isn't the most satisfying thing to hear. So let's talk in a little bit more detail about the legal implications of the policy. So before the implementation of this bill, as I've already mentioned, the United Kingdom has had a relatively difficult history with immigration law and a very difficult relationship with the 1951 Refugee Convention. While the UK is a party to the Refugee Convention, it has gone about implementing policies which some have argued undermines the spirit of the convention in the past. For example, the controversial 2021 Nationality and Borders Bill does make it legal for any person who has travelled to the UK through a safe country to have their asylum claim declared inadmissible. And this is really where we're skirting along the lines of what is considered to be a violation of international law versus what is considered to just be something that is in violation of what I would describe as the spirit of international law. Because the main argument that we have opposing things like the Nationality and Borders Bill is the fact that there is, under the Refugee Convention, no obligation for somebody who is seeking asylum to have to seek asylum in the first safe country that they find themselves. Now, this has never been a part of international law, has never been a part of the Refugee Convention. The only thing that it is that touches on this slightly is the Dublin III regulation under European Union law. Under Dublin III, or the European Union law regulations, we find it the case that if somebody has claimed asylum in one member state of the European Union, and that it is registered that they have claimed asylum in this country, they can, if they then go to another member state of the European Union and claim asylum there, then the member state that they find themselves in there can check whether or not they have claimed asylum elsewhere within the European Union, and if they have the right to send them back to that original country. So that is one instance of international law being having this provision which allows member states to return refugees to safe countries where they've first claimed asylum. The idea of the Dublin III regulation is, of course, to harmonise refugee law across the entire European Union to ensure that we see the ability for somebody, for a member state to check whether or not a particular person has claimed asylum in another member state, and to therefore be able to effectively spread out the number of asylum seekers across the European Union. However, the United Kingdom is no longer a member state of the European Union since we left in 2020 and went into the transition period. So we know that this Dublin III regulation, whether or not it actually applies to the United Kingdom, is questionable because we have now left the European Union. And so the main argument for those who are opposing asylum policies in the past is, why should an asylum seeker try to claim refuge in the UK if they've passed through another safe country first? So they are effectively presenting the line of argument that was in the Dublin III regulation. But in actuality, there is no provision within the 1951 Refugee Convention which categorically states that a person claiming asylum has to claim asylum in the first country they take refuge. Now, despite this, the UK does have obligations under international law as a state party to this Refugee Convention. However, the Refugee Convention has been interpreted in quite an interesting way by the judiciary, because while there is no obligation that an asylum seeker claim asylum in the first country they enter, there is also no obligation on the part of the UK to accept asylum claims if processing is already being taken place in a different, quote, safe country. So, on the one hand, there is no obligation for an asylum seeker to claim asylum in the first safe country they find themselves. On the other hand, there is no obligation on the part of the United Kingdom to accept asylum claims if they are already being processed in a different safe country. And this does bring us on to an interesting case from 2014. And this was the case of R on the application of EM, brackets Eritrea, and the Secretary of State for the Home Department. Now, the facts of this case were very, very simple. There were a group of asylum seekers, I believe there were 4, who had an asylum process taking place in Italy. However, they argued that their rights and the treatment was such that if they were to be returned to Italy, they would be subject to inhumane or degrading treatment, and this would therefore be contrary to Article 3 of the European Convention on Human Rights. In terms of the facts of the case, the Supreme Court accepted the facts of the case as they were, and because the legal issue wasn't whether or not they were actually subject to this inhumane or degrading treatment. That's not what the Supreme Court brought the case for, or the case was brought to the Supreme Court for, sorry. The question of this case was whether or not there had to be a, quote, systematic breach of the international obligations of the state in question, the question being Italy, under human rights law, for the UK to therefore have to deport asylum seekers back to said country. The Secretary of State for the Home Department argued that there was no evidence of a, quote, systematic breach of Italy's international obligations, so therefore they would not be in violation of Article 3 of the European Convention on Human Rights if they deported these asylum seekers back to Italy. So the question here is, and what they did was, the Secretary of State for the Home Department and the Court of Appeal relied on a case from the European Court of Justice, the case of Afghanistan and the Secretary of State for the Home Department, where they claimed that there would need to be evidence of a systematic breach of Italy's international obligations to protect asylum seekers under Article 3. And they argued that while the European Convention on Human Rights and the European Court of Human Rights may have argued something differently, the fact that the European Court of Justice, as a judicial body of the European Union, was therefore, the decision from that court was therefore bound in UK law, whereas the European Court of Human Rights in Strasbourg was not necessarily binding into UK law, in the same way as the European Union was. However, the Supreme Court, while agreeing with that interpretation, because that was a basic interpretation of law, disagreed and instead allowed the appeal and referred all the cases to the administrative court for a determination on the facts of the case. They argued that the question that was debated in the NS Afghanistan and Secretary of State for the Home Department case by the European Court of Justice wasn't whether or not there had to be a systematic breach of international obligations to therefore be in violation of Article 3 of the ECHR. They were just arguing on the facts of that case whether or not a systematic breach had taken place. Instead, the question of law was whether or not a simple breach of these obligations would be enough to be in violation of Article 3, and the UK Supreme Court argued that it would. So we have here some interesting case law regarding the contravention of Article 3 of the European Convention on Human Rights. They argued that ultimately, in this case, it was argued that if there was no evidence of a breach of Italy's international obligations under international law, under the Refugee Convention, under the European Convention on Human Rights, then they would be in the right to be able to deport these asylum seekers back to the country that is processing their asylum claims. So this does raise the safe country argument. And if we come back to the Rwanda policy, some have suggested, opponents of the Rwanda policy have suggested that since the UK has an obligation under both Article 3 of the European Convention on Human Rights and Article 33 of the Refugee Convention to prevent asylum seekers returning to a territory where their life or freedom would be threatened, they have argued that the implementation of this policy, the Rwanda policy, breaches international law for this reason. And the reason why there is a potential human rights implication to this policy is because the state of Rwanda has had a, let's just say, very questionable human rights record, especially regarding those within the LGBTQ plus community. And so we can see that this argument can be presented under both Articles 33 of the Refugee Convention and under Article 3 of the European Convention on Human Rights, and which the United Kingdom, as a member of the Council of Europe, is bound. So what about these claims of human rights abuses against the LGBTQ plus community in Rwanda? Well, last year, the Human Rights Watch report found that there was evidence of arbitrary detainment of gay and trans people in Rwanda, with the accusation of them, quote, not representing Rwandan values. So if it can be shown that the deportation of asylum seekers to Rwanda could subject them to discrimination and to potentially inhumane or degrading treatment, then this policy would be in violation of international law, and it would be in violation of the United Kingdom's obligations under both Article 33 of the Refugee Convention and under Article 3 of the European Convention on Human Rights. But there is also another angle from which we could actually determine whether or not there is a breach of human rights. And this is in regard to the concept of discrimination. Because it seems that, on its face, the Rwandan policy seems to discriminate against certain people who are claiming asylum within the United Kingdom. Now, if this policy does only target specific types of individuals, and, for example, allows, or at least is not binding on to, for example, Ukrainian refugees, which some people have suggested it is not, then we can be looking at a potential discrimination case brought against the government as well. Because if there is a potential issue of discrimination, there could be a potential breach of Article 14 of the European Convention on Human Rights. Article 14 of the European Convention on Human Rights is an article which enshrines the right not to be discriminated against in the enjoyment of the rights and freedoms set out in the rest of the convention. And so the first question that was asked when this policy was announced last week was whether or not this policy was going to be applied to, for example, people who are seeking asylum as refugees from Ukraine, following the invasion of Ukraine by the Russian Federation. Well, there's been obviously mixed messaging on this, and for the most part, people have said that this would not impact Ukrainian refugees, but only impact refugees from people crossing the channel. But then we have a two-tiered system. We have a situation here where we have two people who could both be claiming asylum, who could both have legitimate claims to asylum under international law, being given different treatment, one being deported to Rwanda and the other one being allowed to claim asylum in the United Kingdom, despite both of them wanting to claim asylum in the United Kingdom. This could potentially be in breach of Article 14 of the ECHR. So, all of these are different legal challenges that can be faced against this policy. It is without a doubt the case, as I've already mentioned at the start of this episode, that this policy will indeed be met with legal challenges on probably all of these bases, and probably other bases as well. There are some people who have argued that there are other parts of the convention, specifically the ECHR, that the United Kingdom may be breaching in the implementation of this policy. And time will only tell whether or not these challenges have any merit in law. So, effectively, what do you think about this asylum policy? Forgetting about the general politics, and even if you want to forget about the moral implications of this asylum deal, because a philosophical discussion about the moral implications would be a topic in and of itself. What do you think of the legal implications of this deal? It seems to be the case that the general spirit of refugee law and asylum law globally seems to be at least challenged by this new asylum policy that is being implemented. Will amount to genuine legal challenges that do have merit in law is another question. But it does seem to be the case that, at least in regards to the safe country argument and arguing that Rwanda is not a safe country to send certain people to, this could have merit in law. If you were to ask me which of these two main arguments would have the most merit in law, I would argue that the contravention of Article 33 and Article 3 of the Refugee Convention and ECHR respectively would probably be the more convincing challenge, at least if you ask me, on the face of the facts that are presented so far. But let me know in the comments below what everybody thinks about this asylum deal, and if there is any more questions relating to this particular episode, or suggestions for other episodes that we can talk about, other things we could talk about. As long as the suggestion isn't to talk about the Johnny Depp Amber Heard defamation case, because I think I refuse. Other than that, I will take any other suggestions on board, and I'll see everybody for the next episode.